Good morning, my name is Gabriel Hindmarsh and I appear before you to make application for the Government Sector Constitutional Law and Policy Advisor position. Australia bears the ethos of a proud nation, however with lack of a proud history. The 18th century declaration deeming that Australia was terra nullius at the time of colonisation was the beginning of centuries of oppression for the first Australians. Unfortunately, Aboriginal and Torres Strait Islanders still bear the scars of colonisation, and it is evident with the absence of a voice in our Constitution. Our forefathers established the Australian Constitution to split the control of the law between three different bodies. The separation enables the bodies to act as checks and balances on each other to ensure that no single body is granted complete power. The underlying principle behind this theory is to prevent corruption of power and control over our legal system, hence the power is separated. The separation of powers appears under chapters 1, 2 and 3 of the Australian Constitution. The power to make law is under the legislative function. Chapter 1 of the Constitution enables Parliament the power to pass legislation. The function of the executive power is to administer the law. Chapter 2 of the Constitution states that this power is vested in the Queen, exercised by the Attorney General, who effectively acts on advice of the government. The power of applying law is vested in our court system, under Chapter 3, the judicial function. Section 51 of the Constitution states that Parliament shall, subject to this Constitution, have power to make laws for the peace, order and good government of the Commonwealth with respect to 39 heads of power. Following the 1967 referendum, the words "other than the Aboriginal race in any state" were deleted from Section 51(26), the race as power. The Tasmanian Dam case established that the term race is not a precise concept. It needs to be defined broadly. The amended section now gives Parliament the power to make laws with respect to the people of any race for whom it deemed necessary to make special laws. The deletion of the words "other than the Aboriginal race in any state" raised difficulties in the interpretation. Now Aboriginals are recognised to be a race subject to this section, which allows for the detriment of their race, which has been dubbed as a double-edged sword as found in the Kartinyeri case. The High Court found in the Kartinyeri case that the race's power allows the Commonwealth to have plenary power over the people of any race, so as to enable it to make laws whether those laws are beneficial or detrimental wholly or partially. This effectively meant that what Parliament can enact, it may repeal in whole or in part, meaning there is no constitutional prohibition on racial discrimination. In a 5-1 dissent, Justice Kirby's analysis of the case was that constitutional law should be read consistent with international laws and acknowledged that Australia does not partake in racial discrimination. So when it comes to the interpretation of the race power, it should be done for Aboriginal and Torres Strait Islanders' benefit and not detriment. His Honour's view on constitutional interpretation was that constitutions don't operate in a fixed time and should be interpreted with changing social values. The 2012 report of the expert panel on recognising Aboriginal and Torres Strait Islander peoples in the Constitution established that there was a case for removing the race provisions, Section 25 and Section 51(26). Professor George Williams argued that the suitable course for fixing the race power is to give power to the federal parliament to pass laws for Aboriginal and Torres Strait Islanders. This grant is to be consistent with the way the High Court interprets a constitution and would be a broad approach that enables interpreters to cover previously enacted legislation and for future legislation for Indigenous people. Among Australia's constitutional history, 44 referendum proposals have been put to the Australian people, and of the 44, only 8 have been successful. It is clear from these statistics that passing successful referenda to enshrine a voice for First Australians poses some difficulties. Constitutional lawyer Professor Toomey's explanation for so many unsuccessful referendums is that there is an instinct to vote no to prevent mucking up the Constitution. The effect is that people realise that any change that is made will be around for a very long time. The process for altering the Constitution is provided under Section 128 of the Constitution. It begins with a proposed amendment to the Constitution that must be approved by double majority, that being a majority of electors in a majority of states. Before the referendum can be held, a bill must be passed by a majority of houses of Parliament or passed twice by one house and encompasses the proposed amendments. The referendum must be held between 2 and 6 months of the bill being passed, and in the 4 weeks after the bill is passed, the yes and no case is provided by the members and senators. If there isn't an opposition to the amendment, then there only needs to be a yes case prepared. A booklet is then provided to each elector no later than 14 days before the referendum. Demonstrations of referenda that has been successful in establishing recognition of Indigenous has occurred in Canada, New Zealand and the United States, all of which have similar constitutional and common law traditions. In 1882, the Canadian Constitution introduced a Charter of Rights to secure legal and formal recognitions for three distinct Aboriginal groups, namely the Indian, Métis and the Inuit. The Canadian Constitution was patriotic from the United Kingdom following the passage of the Constitution Act 1982. The Act entrenched the Canadian Charter of Rights and Freedoms in the Canadian Constitution. Section 35 of the Constitution included a provision recognising and affirming existing Aboriginal and treaty rights in Canada. Subsection 1. The existing Aboriginal and treaty rights of Aboriginal peoples of Canada are hereby recognised and affirmed. Subsection 2 defines who the Aboriginal people of Canada are. Subsection 3 states, for greater certainty in subsection 1, treaty rights include rights that now exist by way of land claims, agreements, or may be so acquired. The best step forward for recognition is a policy that creates a first Australian body in Parliament to connect the Aboriginal and Torres Strait Islander community with the government and tie an everlasting bond. This body can consult with the Aboriginal and Torres Strait Islander peoples, then advise government on future or current laws and policies affecting them. If this were to be encoded in the Constitution, it would symbolise an eternal voice for our first Australians. As the Uluru Statement of the Heart says, with substantive constitutional change and structural reform, we believe this ancient sovereignty can shine through as a fuller expression of Australia's nationhood and will allow all Australians to enjoy this beautiful land harmoniously.